Randy, you have 10 minutes.
Great. I wrote my questions out and I made my comments out, and given the circumstances, I'm glad I did, because it would be harder for me to vamp this year than it might have been in other years. So let me just deliver them as I wrote them. And I want to thank Mike and Mike for inviting me to be on the program again this year. For some time, originalists have been divided on the proper role, if any, for what has been called constitutional construction. The immediate provocation for this debate was Jack Balkin's 2007 article, Abortion and Original Meaning, in which he invoked the concept of construction to defend Roe versus Wade. For some, if the distinction between interpretation and construction could legitimate this type of argument, the distinction itself was something to be repudiated. This is what Mike Rappaport and John McGinnis attempted to do with their theory of original methods originalism. In part, this rift was the fault of Larry Solom and myself when we initially described the activity of interpretation as identifying the, quote, semantic meaning of the text. In his unpublished paper, Larry defended what he called semantic originalism. Because bare semantic meaning is extremely thin, it leaves a very wide field for constitutional construction. It is no coincidence, then, that Jack continues to invoke semantic meaning when discussing interpretation. Larry and I, however, came to realize that interpretation was more accurately conceived as identifying the communicative content of the text. Semantic meaning contributes to, but is only a part of the communicative content of the text, which is conveyed by its semantic meaning as enriched by context. This conception of interpretation yields a much thicker original meaning. Now, part of this rift, however, amongst originalists was a product of a distorted reading of my account of originalism in restoring the lost Constitution. Although I insisted there, and continue to insist, that any approach to construction requires normative justification, I never said, and I do not believe, that judges in the construction zone should engage in case-by-case normative reasoning. The only rule of construction I advocated was an across-the-board presumption of liberty to replace the current selectively applied presumption of constitutionality, which relies on judges to selectively, again, identify fundamental rights in need of special protection. Now comes Will Bode and Stephen Sachs with their paper, The Law of Interpretation. I cannot resist analogizing this to two kids trying to get their parents to stop fighting. I tried really hard to resist saying this, but I couldn't resist saying it. So if this analogy sounds in any way demeaning to Will and Steve, just imagine that the kids in the story are fully grown adults and the parents are in their 50s and 60s, like on Seinfeld. Will and Steve are simply proposing that judicial discretion in the construction zone be cabined by the rule of law. Now, as an aside, I need to inform you that I learned during the debate over Obamacare that the word uncabined is a lawyer's term. I actually didn't know this, but if you say that word to anyone who's not a lawyer, like a reporter, they will say, huh? What did you just say? What did you just say? And then you have to reply, oh, I meant limited. So just so you know, don't say cabined or uncabined to anyone who's not a lawyer. Well, anyway, they're arguing that judicial discretion in the construction zone be cabined by the rule of law. And what Will and Steve call the law of interpretation consists of two types of largely unwritten rules of law, which they call linguistic rules and legal rules. This is a crucial move, because what they call linguistic rules attempts to ascertain the communicative content of the text. They are part of what I call the activity of interpretation. And because what they call legal rules are unwritten default rules that give legal effect to what the linguistic rules identify as the meaning of the text, they govern and constrain what I and others have called the activity of construction. In light of the fact that Will and Steve quite clearly distinguish between the activity of ascertaining meaning and the activity of ascertaining legal effect, I think it remains a little confusing and possibly misleading to readers to say that both sets of rules comprise what they call the law of interpretation. But I, and I believe Larry also, have always maintained that it is the substance that counts, not the labels that one chooses, as long as one's clear about what's meaning. And so it's with the substance of Will and Steve's categories of unwritten rules that I have no objection. Will and Steve's distinction between linguistic and legal rules sheds light on where I always thought that Mike and John were on the right track with original methods originalism, in which I must freely confess, they moved me on this position. Their argument did affect what I think about the activity of interpretation in the following way. While what Will and Steve call linguistic rules, in effect at the time of enactment, were not themselves part of the original meaning of the text, like then existing rules of grammar, these widely shared rules are part of the communicative context of the text. These original methods do contribute to the activity of interpretation. In that sense, while the original meaning of the text does not literally include these linguistic rules, it is informed by them. In other words, if our law is a search for the original communicative content of the text, then our law includes the linguistic rules or original methods in effect at the time of a text enactment that determine this content. Most importantly, assuming that we have a legal rule that says courts should follow the original meaning of the text, a legal rule that says courts should follow the original meaning of the text, the linguistic rules in effect at the time of the adoption of the text cannot be changed without being unfaithful to this meaning. Put another way, to change the linguistic rules is to amend the text without going through the amendment process as required by Article 5. But what about what Steve and Will call legal rules? They say, quote, "What matters are the original adoption rules, which happen to fix both the original linguistic meaning and some, but not all, of the linguistic rules," unquote. In particular, they leave out any application rule that might have changed since adoption. They define an application rule, one of them, as an instruction to decision makers to resolve any future uncertainties with an eye towards settled practice. So let's take an example. Take the presumption of constitutionality. Certainly the text of the Constitution contains no such rule of construction. By some accounts, there was a rebuttable presumption of constitutionality of some kind at the founding. For example, John McGinnis describes a duty of clarity before finding a constitutional conflict. I learned Mike Rappaport is not entirely convinced that on the basis of the evidence there was such a duty, but that's John's position with respect to the founding. John Jackson has claimed that in state courts prior to the 14th Amendment and in federal courts after, there was a rebuttable presumption of constitutionality, which was then replaced briefly by a presumption of liberty, at least in the Lochner decision itself. This then was supplanted by a rebuttable presumption of constitutionality in O'Gorman and in Caroline Products, before being replaced in the 1950s by a Thayerian Holmesian irrebuttable presumption of constitutionality in the absence of a fundamental right or suspect class. And this application rule has been supplemented by a rational basis with teeth approach that sometimes applies and sometimes does not apply for reasons that we've never been told. Now, if the last iteration of the legal rule is our law today, can it now be changed? I think the answer is yes. This is not because, as I believe John McGinnis would contend, because the one particular version of this presumption was in effect at the time of the founding, and that should be restored. I believe it can be changed because the current application rule is ineffective and even an unfaithful way of putting into effect what the Constitution does say, which highlights two implications of Will and Steve's approach that merit further consideration and discussion. First, assuming we can identify what the current application rules are, the positive law today, on what grounds do we change these rules over time? They need a theory of change. My answer to this requires a better theory of construction than we currently possess and that I currently have. My own notion, which I hope to develop in the future, is, as some anti-slavery constitutionalists did, is to distinguish between the letter and the spirit of the Constitution. I actually saw some of a similar kind of argument in Mike and John's paper for the conference. The letter is a matter of interpretation, and the linguistic rules, the spirit is guided by a good faith attempt to effectuate the letter rather than to evade or undercut it. This would just be a possible take at a constrained view of constitutional construction. The second and final point I wish to make concerns their treatment of normativity. I agree with their lengthy defense of the conclusion that, quote, there are good reasons for these rules to be established at the level of law, whether written or unwritten, and not simply left to the normative predilections of individual judges or officials. I totally agree with this. Responding then to my claim that interpreters need a normative theory for how to construe a constitution when the meaning runs out, they respond, quote, that's true, in the non-unique sense that the problem of political obligation is not yet solved, and that an individual moral actor always needs a normative theory to justly following or violating or ignoring a legal rule. They then identify their approach as hardy and positivist. That's fine for purposes of this article, and it's to their credit that they acknowledge the issue and their own priors. But what exactly one thinks is law, and more importantly, whether and whatever law may be binding, might have an important implication for why originalism is the appropriate method of constitutional interpretation. For example, must the substance of the Constitution be above some normative threshold before it merits the duty of obedience and respect as positive law? And which is, I think, the territory that Jeff and Kevin are pursuing. And might it also matter whether to follow whether to follow any particular rules of application may be accepted? It might also matter for whether to follow any particular rules of application that may be accepted as law at any given point in time. In conclusion, I want to note that I read an earlier version of this paper when it was presented at Larry's seminar at Georgetown. The paper is so immeasurably better from what I read before as to be unrecognizable and satisfied most of the very strong objections that I made to it at that time. I now consider this a very constructive, and if I may use the word, very constructive, if I may be allowed to use that word, basis on which originalists and originalism might best move forward. I was tempted to conclude this talk by returning to my metaphor of the kids trying to stop the parents from bickering with each other, but I have resisted that temptation. Thank you, first of all.
Yeah. I'll just say three things, I think, and then we'll let questions. So, on the stop fighting, I think that's exactly right, actually, and I'm glad you said it. I think there will be a lot of fighting among our parents at this conference, and we just wanted to get out in front of it and suggest that maybe it doesn't have to be that way. I'm sure it will happen anyway. But that is sort of part of the motivation of much of what we say about construction. Is we see a lot of the disputes to be more terminological than substantive, and maybe bringing in our own new terminology will just make things even worse and cause outsiders to the field to think, what is going on over here. But the goal is some kind of rapprochement. On a theory of change, I think it's right that we need a theory of when and how the unwritten law changes. I think both of us have priors that, in general, individual judges are not empowered to change the common law, that they're supposed to apply it, not make it. That said, sometimes law changes anyway, whether judges want it to or not. The same way the rules of grammar change, even though no individual one of us is empowered to make up new rules or new sentence structures. Sometimes it does happen, and that raises some of the hardest questions about how the rules change. And I also agree that the paper doesn't have in and of itself its own normative theory. While we're incorporating other work at the conference by reference, I'll say at least I have been heavily persuaded by Richard Ray's paper on Promising the Constitution, which argues that a lot of the normative power of law for judges comes from the oath, and that the decision by a judge to take the oath gives them a strong normative reason to obey it. I think it's totally right that a judge thinking about whether to take, say, a constitutional oath should think long and hard about the Constitution and whether they're willing to take an oath to it. And it should have some sort of minimum normative content before they do. I think it's probably also right that there's some level of Constitution so bad that the right thing to do is to take an oath to it falsely, intending to get inside the system and then, blow things up. I think that's probably a fairly a threshold our Constitution, thankfully, is well above. But that's a question for more discussion.